Hello there. Today we're looking at Hallucination-Free, assessing the reliability of leading AI legal research tools. This is by a set of researchers out of Stanford and Yale, as you can see here. Now, I know on this channel we usually look at more kind of core machine learning stuff and so on, but this particular thing, it happens to be a thing that I know something about because maybe many of you don't know that, but in my day life, I am CTO of a company called Deep Judge. We make legal tech products. Specifically, we make search engines for internal document collections of like large law firms and adjacent fields and so on. So while what we do is not super directly exactly what this paper tackles, the sort of broader industry of legal tech is very familiar to me, and so this caught my interest. And maybe today I can bring that interest to some of you. And what I do find interesting is that the techniques that are developed, by researchers and us doing all kinds of stuff. These techniques are right now being exported into the broader world, into the mainstream, and they are being applied, and real companies are trying to build real products for real people who are not machine learners out there. And that's so research like this, like looking at how this impacts the real world, will actually help you in order to just sort of develop better things, but B, also have a mind for how later what people actually would like to do with this kind of technologies. So that being said, what is this about? This is about so-called legal research tools. A legal research tool is a tool that you would use to answer legal questions based on publicly available data. So if I say, well, can I don't know, turn right on a red light? To you Europeans, you don't know this, but in the US, even if a red light is red, but you need to make a right turn, sometimes in some states, you're actually allowed to do that. So it'd be a legal question. Hey, in Delaware, am I allowed to turn right on a red light? The legal research tool would need to go to publicly available documents to answer that question. So usually, if we disregard AI, usually these tools allow you to do that search yourself. They have big databases of laws, of case law, right? What have judges said and so on? What has, inter-country treaties, what do they say? What is commentaries of professors and so on, curated content? Like, these companies sell these big corpora of very good content, including public sources, including proprietary commentaries and so on. And you're then able to go and drill down and find your answer. Now, all of these companies are starting to add AI into the mix. And by AI, they mostly mean generative AI, like ChatGPT, like AI, in order to assist you. So you can just enter your question. Hey, in Delaware, am I allowed to take a and the thing is supposed to go by itself and collect together the facts and collect together the necessary relevant previous cases and so on, and then reason through that and give you finally an answer with references. This paper here tests the accuracy of those systems, specifically with respect to what are called hallucinations. So the tendency of large language models to make up stuff. And they're going to reach the conclusion that even though these systems sort of advertise themselves as being hallucination-free, they are not. They still make quite some mistakes. And they do say that may be problematic for the legal field and so on. Now, I have opinions about this paper. Notably, I think everyone involved here is kind of shady. Like, the researchers have done and are doing kind of shady stuff. The companies are definitely doing shady stuff, especially in terms of how they advertise these things. The legal field as a whole is shady in terms of what they're afraid of and what they expect out of these systems. And like just everyone is kind of shady for just talking about the wrong thing. Like the fact that people expect you can apply LLM based systems in order to end solve tasks like this for you is just the fundamentally wrong approach to use these technologies. Like it's just, if you ask any competent machine learning person, you just get like a, just don't do that. Like just, this is not a place where you want to apply these things in the way that people expect. In any case, we'll go through the paper. The paper, and as an abstract, they do give an overview over the current landscape of sort of legal tech, especially with respect to generative AI and these legal research tools. Then they make a data set. The data set has some of these legal questions, one that I just presented before, but obviously much more complex, much more in depth. Then they evaluate that data set on these systems, and lastly they present the results, and the results are going to be, as you can see right here, that these tools still between a fair bit of time. On the positive side, the hallucination rate is much lower than, is lower than when you just plain use a straight up LLM like GPT-4, and so that's good. And that is mostly due to their use of retrieval augmented generation. So the technique of retrieval augmented generation, also called RAG. Now, I cringe every time someone says RAG, and I've also started saying it, like it's retrieval augmented generation. Whenever stuff goes mainstream, it needs to be like shortened and made catchy. The biggest offender in this is the word Gen AI, like but in any case, so you'll probably also hear me using these terms, but feel free to comment one cringe emoji for every time you hear me saying this. So retrieval augmented generation, where an LLM works with a search engine to actively grab relevant resources, pulls them in, puts them into the prompt, and then answers your question for you, drives down hallucinations, but doesn't fully alleviate them. And we'll go into some of the reasons. And I do think the reasons for this are very informative to people who just work with these things on kind of like test date. Here's my 200 personal documents and I use Llama Index on them and so on. Like the real world is much more complicated than that, and a lot of that's the culprit for a lot of these cases right here. All right, now to what I said at the beginning, our company, how is that related to this one right here? So we make search engines, but we make search engines for internal document collections of companies, not public documents. So whereas here you mostly care about legal precedents and laws and rules and contracts between countries, in the internal document universe you mostly care about the question, have we done something before? Like, I have a new case, have we done something like this before? Can I go look up? Can I find a good example? Has my colleague already given advice on this particular topic and so on? So kind of different worlds, different use cases, and different requirements to these systems. And the thing that people want out of these public research tools, I do strongly believe that in the current state, applying LLMs like they do is just the fundamentally wrong thing to do, and expecting LLM systems to perform these tasks, these public legal research tasks, is just a fundamentally wrong expectation. Like that's just not what they're for, and you're trying to apply the things to something they're not made for, and then you get garbage. Then I'm sorry, that's the situation. All right. Yeah, as I said, these systems promise to perform complex legal tasks. However, their tendency to generate incorrect or misleading information, a phenomenon generally known as hallucination, that's what's holding them back. Hallucination. What is a hallucination? This paper is going to define it as incorrect or misleading, like making up stuff. To the machine learning world, we would have a bit more of a nuanced idea of a hallucination. So essentially, large language models are statistical description of language, right? It's a model, meaning a statistical model of a language as seen through a training corpus, a training data corpus. Now, LLMs are nowadays, they are relatively surface level statistical descriptions of language. So, and then I don't mean to sound like Gary Marcus or so. I mean, like, oh, it's just a bit of, and so on. No, it's very powerful, but still, it is a statistical description on kind of a linguistic, grammatical level. They're very good at predicting the next token in a statistical sense. So they just see the world in terms of likelihood of the linguistic patterns of language. They don't see the world in terms of reasoning or something like this, and certainly they do not have some sort of internal world model. They do not have a grounding in reality. All they see is text and the statistics above it. So what is a hallucination? A hallucination happens because the real world does not follow a smooth likelihood distribution that the LLMs learn from the training data. So the LLMs from the training data, they learn a relatively smooth probability distribution across language. So stuff is more likely and less likely, right? And then what they produce will be exactly proportional to how likely they think a given piece of text is, just from a linguistic perspective. However, the real world doesn't follow that. In the real world, you have things that are true that are quite unlikely from a linguistic perspective, and you have things that are untrue that are quite likely. So the real world is much more like so, I guess, or skewed or something like the real world is not a smooth probability distribution where the what's statistically likely is also exactly proportional to that true. And therefore, these gaps here, the gaps between what's likely and what's real, like here on the negative side and here in the positive side, these gaps are where hallucinations happen. Namely, you can see at this particular point, I'm at I don't know, imagine this is a particular sentence that just sounds very plausible, but is just not true, right? That's where language models hallucinate. They will produce the sentence even though in the real world, even though it's quite likely, but it's just not the case, right? You all know such situations where something is quite likely, is quite plausible and so on, but just isn't. On the other hand, right, over here, we see something that's true, but that is just very unlikely. And coincidentally, so the world has unlikely stuff that is nevertheless true. In fact, it would be very unlikely if there were no unlikely true things, right? That as a meta statistic would be a quite unlikely world. However, language models, the way they learn language is an over smoothed, over narrow representation of language. We might get to a place in the future where they learn from the training corpus such a deep representation that they accurately can assess the likelihood of stuff. Then there's still the debate of how much of the information that you need is actually contained in all of the world's text, and is there information that is never written down in text that you would need to know in order to in order to have the accurate likelihood. I think that's of now more of a philosophical question, but I hope you can see here some stuff is likely but not true, some stuff is true but not likely, and that's where hallucinations happen. In this paper right here, they take a more kind of basic approach of just saying, well, a hallucination is kind of stuff that's wrong. and they're going to define it later. These are going to be the results after they run their data set through. So they test different products right here. They test, first of all, GPT-4. GPT-4 without any grounding whatsoever. They just ask GPT-4 these questions and they just see what happens. And as you can see, GPT-4 does get it wrong quite a bit of times. And yeah, so the goal is obviously, hey, this is what people know as hallucination. Can we do better than that, right? By doing retrieval augmented generation. We'll get to what that is. Actually, we'll get to what that is right now. So let's go to that. What is retrieval augmented generation? It's a way to enhance large language model generation by augmenting that generation with retrieved data, retrieval augmented generation. So you have the user inputs a query, which in this case is a question, kind of a natural language question. Hey, in the state of Delaware, can I do this? Now, what usually would happen if you just were to go to, I don't know, ChatGPT or something, or a plain large language model, you would just give that to the language model, and that language model will give you an answer. And the way it does that, again, from its training data, is learned a statistical distribution over language, and therefore it's going to give you the output that's likely to follow given your input. So likely to follow according to the training data. Now, for a lot of questions, the likely output is actually also true. If you ask it, hey, can you make me a day trip in Rome? Like, suggest some things to me. There are a million blogs on the internet that have, my itinerary for my Rome day trip and so on. It's going to do just fine, right? However, it's going to do not so fine on some of these legal questions. First of all, because again, there is very detailed knowledge and so on. Second of all, and that's what we'll get to later, legal question answering in the sense of, I need to retrieve stuff from these public sources, requires reasoning, requires explicit sort of construction of relevant context, and that's also not easy. Requires knowing which stuff even to apply, which stuff is out of date, which stuff has been overruled, and so on. So a lot of stuff that's not actually just what's likely and what isn't given the training data, because, well, the training data is just a big blob of text, completely unordered, completely no particular date ordering and cut off after some point. So with retrieval augmentation, we can overcome some of that. So what you would do is you would use a search engine, and that's what you see down here. You would use a search engine in order to retrieve data from what they call here a knowledge base. So the knowledge base, that would be these vendors of these products that they test in this paper. They would have knowledge bases that they maintain and they curate. So they take all the case law that is produced day by day, add it to the knowledge base. They would take, articles that their experts write, add it to the knowledge base, and so on. Just accumulate that. So you use a search engine across that, and you retrieve relevant documents to your to the query that the user has. Then you give the documents to the LLM along with the question. So the way that works is usually this query, it would come somewhere here, and you just ask the LLM. You maybe have some pre-prompt, you are a very competent legal assistant, yada, yada, yada. The user asked the following question, and then here you would put that question from the user, please answer the user, and so on. So this would be your prompt, and then the LLM would output some sort of answer. And what you're going to do with retrieval augmented generation is you're going to take the documents that you get from here, and you're going to stick them in the prompt as well. So rather than just plainly saying, hey, the user asked the question, you're going to maybe also have a pre-prompt, you are a blah, blah, blah. But then you're going to say, here are some, sorry for the handwriting, some relevant search results. And then you're going to list the search results, here. You're going to list the results you get from the search engine. And then down here in the prompt, you say something like, okay, the user asks this question, please answer based on the above references. References, yeah. And now all of this here would be what you typically say is the prompt. So you would stick all of that into the LLM and then get out. So the LLM no longer just gets, oh, hey, the user asked this following question, and it has to answer from memory, basically, of the training data. But now you also provided, you say, hey, look here, the user asked question, and here are some references. Please base your answer on those references, if possible, or something like this, right? So you immediately see how that makes stuff better. If these references are actually useful to answering the question, then an LLM, being able to access all this information explicitly in the prompt can be much more capable than one without. So even if something has never been mentioned in the training data, it can know, quote unquote, about it, because you're just giving the information to the LLM explicitly. Even if it was in the training data, LLMs don't remember the training data explicitly. They just sort of have a statistical abstraction of it in their head. So giving them the information explicitly during runtime helps. In fact, if you ever want to try retrieval augmented generation, you can just do that yourself by mimicking this. So just have your question, grab a few relevant references that would be necessary to answer the question, and just copy paste all of them into the prompt of an LLM, and then put your question below and tell it to, use the references above. It's literally, there's nothing else. This is literally it when you talk about retrieval augmented generation. Now, there are various prompting tricks and so on, and you can have a second prompt that checks and be like, ooh, criticize yourself and blah, 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 things step by step and so on. Like all of these things, the usual prompting tricks apply, but in essence, this is the core. You just copy paste some references into the context of the LLM, and then you ask it to use those references when it gives the answer. So that just demystifying RAG here. This is what happens. And you can immediately see how it helps, but you can also immediately see how it cannot help. Namely, hi, this is Yannick from the future. A short interruption of something that I think I failed to properly explain right here. So the LLM on the right-hand side is really completely disconnected from the whole system on the left. So all the LLM sees is this prompt. It doesn't know that there is more data. It doesn't know about your case other than what you describe in the prompt, right? The prompt is the whole world to the LLM. And that explains a lot of, what's going wrong right here. It has no clue that you have chosen these search results based on specific criteria and so on. And you can try to bring that into the prompt, but it will not help by much. So if you just think what the thing on the right-hand side here, this prompt, the few search results completely out of context and the user query and your instructions, that's all the LLM ever sees and is ever aware of existing. And the whole system on the left and all the circumstances and all the knowledge about that, it doesn't know any of that, right? So once you start thinking like this, you can see where it goes wrong very often. All right, back to Yannick in the past, who's making a few more in-depth explanations around this topic. If these things here aren't relevant, you're actually making stuff worse by telling the LLM, please base your answer on the search engine results from above, right? Please base your answer based on them. It's going to be like, okay, I'll do that. But if they're not relevant, yeah, so you may change the prompt to, oh, please only do so if they are relevant to you. That's going to help sometimes. However, if you know from, I don't know, if you have search engines, they sometimes miss. So they sometimes give you something that looks relevant just because the text passage kind of deals with the same topic, but isn't. Like completely different context, or it's been overruled, or it's, you know, it's confused by something. You're actually making stuff worse if you do that. So one of the lessons here is that retrieval augmented generation can certainly help and does help in a lot of cases, but it brings its own set of problems with it, especially when there is reasoning involved, right? Retrieval augmented generation is really good if you just wonder, okay, I know there's something somewhere, I need to find it. So if you treat it essentially like a good search engine that also reads a lot of stuff and points you to the things that are relevant, it's a lot better at that than end to end solve a task for you, where reasoning is involved at the retrieval step. Like, what do you even search for? That's already a challenge. And then how do you make sense out of the answers? That's the second challenge. And if those things involve complex multi-step reasoning and abstraction, and certainly these legal questions do, then that's really not the right place for LLMs to be involved. Also, yeah, you can see this lexical and semantics. So there is this modern idea that you can either do keyword search or a vector search, and that's it, right? Like the last 50 years of information retrieval, it just don't exist anymore. And yeah, so people go with, oh yeah, keyword search, that's the old way, and now the vector search, and everyone's just so hyped by being able to chunk documents and then just embed them and throw them into a vector database. And I think that's just going to solve all of their problems because it's neural networks and it's cool and it's modern. There is way not enough focus on what it means to build good search, and you know how that's being done. Just because people in front of their gloomy eyes have this, neural networks, APIs, and vector databases. Nevertheless, yeah, so you see the retrieval of relevant documents is quite important. I would say apart from the fundamental mistake of using generative AI for reasoning based tasks, like that's just don't do it. Apart from that, what influences the quality of these systems the most is how relevant the reference data you can ship into the prompt over here is, and therefore the retrieval aspect is crucial. Again, that again has multiple things, like what do you even put into the retrieval? And I do think in this case right here, like the legal AI research tools, that's a giant component. Second component, what's even relevant? And the relevance in these public research tools, the relevance is often determined by stuff that's not contained in the document. The relevance is often determined by stuff that the humans know because they've gone through extensive education as lawyers, and it's not something that you want to just be like, whatever the search engine outputs, I'll just take all of that and base my answer upon that. That's just crazy. Yeah, so this is retrieval augmented generation with its good things and its flaws and so on. And yeah, we're going to look at what ultimately comes out. So they test 4 products. Back to this. GPT-4 without retrieval augmented generation, just plain up language model. Actually doesn't do too well when you consider that it just needs to remember everything that it says is from kind of like memory of the training data. Then LexisNexis is a company. They have Lexis AI Plus or so their product is called. It's for doing this type of legal research. It does the best out of the ones tested right here. But as you can see, its hallucination rate is still considerable. So 1 in 5 times it still tells you something that's not true, or grounded in something that's referencing something that's not to be referenced for that case. Westlaw is by a company called Thomson Reuters. It is slightly worse, or well, I guess double worse than the Lexis AI Plus. However, keep in mind that the benchmarks that these academics use is also targeted to elicit some of these hallucinations. So in practice, it might look totally different. An interesting story is around this practical law entry that they have right here. So practical law is another product by Thomson Reuters, so the same as Westlaw. Now, you may ask yourself, it's a bit odd here. It seems to do okay well on the hallucination front, but then the incompleteness of it is quite high, right? So what's kind of going on here? What's going on is that practical law is a different product. It's a much more restricted set of just very curated content. So what people would go there for is, for example, I need a really good template for a contract, right? And then practical law would have their lawyers write a bunch of these, these are the gold standard templates for the industry or something like this. They would also write very like legal opinions and so on, I believe. So very expert made content. So you can see the difference. These two products right here, they'll have much more extensive. They'll have the case law, they'll have stuff like that. Practical law doesn't. And so the thing is, this is the wrong product to evaluate, right? And the clue is, the first iteration of this paper didn't have Westlaw, it just had practical law. So they picked the wrong thing to evaluate. And so this is, I don't know, academics, this is where they get a bit shady, I do find. So they picked the wrong thing to evaluate from Thomson Reuters. And I've seen articles, and I'm not sure what the exact order of events here right is, but they keep complaining in this paper that, these tools are not openly accessible, which makes them really hard to evaluate. Specifically with respect to picking the wrong product to evaluate, they said, well, we asked Thomson Reuters 3 times, and they wouldn't grant us access to evaluate it. Now, what I wasn't able to fully deduce from these answers was, did they ask Thomson Reuters for Westlaw and they didn't get access to that, and that's why they chose to use practical law? Or did that somehow happen differently? But the way I can deduce it, they said, well, we asked for access to Westlaw, they didn't give it to us, so we evaluated practical law. If that's the case, or if any of the other variants is the case, right? If you already had practical law and also wanted Westlaw and didn't get access to it, or if you got access to neither from Thomson Reuters, but then somehow otherwise got access to practical law, all of these are a bit shady, I find. Like, just evaluating the wrong thing just because you don't have access to the correct thing isn't, that's not good science. And then the interview said something like, once we did publish our findings, then Thomson Reuters gave us access to Westlaw. Well, you evaluated the wrong thing, and you essentially blackmailed them into giving you access, which you have no right, right? So in whatever order that happened, I do find it highly shady of these academics to do something like this. And yeah, also, what is funny though, in the Thomson Reuters case, you can see in their metric, now obviously their metrics are made in a particular, but in their metric, then the correct product actually scored a lot worse than the incorrect product right here. It also scored a lot worse than this Lexis product here. So this difference here, I would say, is notable. But this difference over here just shows you that there is something wrong with this benchmark, right? If the fundamentally wrong product for a thing gets about equalish good in terms of hallucination. And let's be clear, this is the thing that they're going to report in the press. The fact that this here is different, and the fact that that indicates that you probably shouldn't use this metric, or you probably should be very careful how to interpret this metric, that completely goes lost. And I do believe, just also from the rest of the paper, that's not that unwanted by the academics right here, because every academic, they really profit if their paper gets widespread attention, so on. So more they can make it seem like, oh, these things still hallucinate. But I do feel the inclusion of this and the fact that this is kind of as good, if you will, as this here, which is explicitly made for that, should give you a hint that maybe the metric here is, just be careful how you interpret any of that stuff and what it exactly means, rather than jumping to be like, oh, it hallucinates. The whole legal field is kind of annoying me right now, because they're just running around like chickens and just saying, oh, it hallucinates. And I don't know, the fact that you think that is a problem just means there's a fundamental misunderstanding of what these tools should be used for, right? Yes, they hallucinate and so on. Yes, that's a problem. Yes, you can bring that down, but so bit shady. These people are from Stanford, and Stanford is kind of known to let's say put a high emphasis on how they market their research rather than just scientific pursuits of knowledge. Good. So looking into these products a little bit more, what I do find interesting is, they say here, yada yada, that these legal technology providers have claimed to mitigate, if not entirely solve, hallucination risk. They say their use of sophisticated techniques such as retrieval augmented generation largely prevents hallucination in legal research tasks. Now, I would concur with that. So it certainly, and even according to this paper right here, the use of retrieval augmented generation does seriously reduce this problem of hallucinations, right? Where the models just make up stuff. Not only in legal research tasks, in pretty much any task where the outcome should be based on knowledge that's somewhere in a repository. However, look at what these providers advertise, and here is where I'm on the side of the academics. Like, the fact that these companies advertise their products like this gives these academics every right to tear them to shreds. So like the nuance between, yes, retrieval augmented generation does reduce hallucinations seriously, right? You can give references, which helps people to even more make sure that what the LLM says is correct and so on. The difference between that and this, unlike other vendors, however, Lexis AI Plus delivers 100% hallucination-free linked legal citations connected to source documents, grounding those responses in authoritative resources that can be relied upon with confidence. What is this? 100% hallucination-free, relied upon with confidence, and so on. Now, this is ridiculous, but the astute, the focused among you might have realized the following. They're not saying that the outputs are 100% hallucination-free. They're saying the linked legal citations are 100% hallucination-free. So as long as they, only link stuff that they actually retrieve from their database, then their claim is technically correct, right? Now, well, first of all, interestingly, The LLM can still hallucinate citations, but I guess in the UI they can only they can restrict the UI to only show actual stuff from their database. So this is a statement that is technically correct. However, you know it's like you know that the people who made it were extremely aware of what they were doing. And so I like every piece of study of this paper or other papers that come out and trash these products for still making a lot of mistakes is deserved, because they knew what they were doing, right? A person who reads this doesn't read, oh, oh, only the citations are hallucination free. This statement says nothing about the accuracy of the response. No, 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 no. They know that what people read when they read this, what they understand, is that the outputs are hallucination free. The sentence doesn't even make sense. Unlike other vendors, Lexia delivers 100% hallucination-free linked legal citations connected to source documents, grounding those responses in authoritative resources that can be relied upon with confidence. Again, what can be relied upon? Not the responses. The authoritative resources can be relied upon with confidence. So this statement says no. This statement essentially just says we have a database of real stuff. That's what it says. It says nothing about the LLM. Those responses, just maybe it refers to a sentence prior to this that we don't see right here, and that's obviously a case here. The paper cherry picks the most egregious marketing things of these companies. But still, the sentence in itself doesn't make sense. Grounding those responses in authoritative resources, well, you just told us something about the linked legal citations, not about the responses. So yeah, unless there is a prior sentence that says something about the responses of the system, this is crafted to transmit something that's not the case, while being made such that at any point you can say, oh no, only the citations. We clearly meant only the citations are hallucination free. So yeah, I have no sympathy for any of these companies then whining. Case text: unlike even the most advanced LLMs, Co-Counsel does not make up facts or hallucinate, because we've implemented controls, reliable data sources such as our... I mean, yes, they have implemented controls, however, does not make up facts or hallucinate. Like, ask one of your engineers, and I'm pretty sure they have protested when these kind of statements are being made. These companies need to make money, right? And sure, like, I get it. You put your best foot forward and so on. You advertise something that's maybe even a bit aspirational, right? All of that is fine. Like, every single company in the world does this, and we all understand that. And even better, it's kind of a you're striving and like, I think we can sympathize with that. But this is just a plain wrong statement, right? Even with the best references, even if you have all the correct references in your context, which is extremely unlikely, but even if you have the correct ones, the correct, even this, and then this has been overruled by that and so on, and even if your LLM is actually capable of doing reasoning across those, which isn't the case, even then it's going to hallucinate some of the time. So no, this is an incorrect statement, and I'm sure again, these are kind of cherry-picked things. Yeah. Thomson Reuters: we avoid hallucinations by relying on the trusted content, yada yada, building in checks and balances to ensure that our answers are grounded in good law. Based on and so on. So this is probably the most kind of timid, the most accurate. It just says we avoid hallucinations, which could still mean they happen, but just kind of they're reduced. So this gets a slight pass, I would say. In the world of marketing, that's fine. So, but this here, this, I don't know. This is shady. All right. There's a lot of prosa in here about giving you kind of the background of the legal industry and so on. However, I want to dive into what they, how they see retrieval augmented generation in terms of the legal industry, how they make their data set and evaluate it, and a bit more on the results. Don't want to make this video too long. Yeah, so retrieval augmented generation, the idea behind it, I guess we've had this all, but it's the idea is essentially you're letting the model go open book instead of closed book. However, it's not as easy, and that's mostly because open book is good, but which book do you look at? And if the fact that which book you want to even look at and what do you want to look up already requires a 4-year law degree or serious experience in industry, then it's probably currently not the right time to just do LLM-based retrieval augmented generation and let the thing do it for you. Limitations of retrieval augmented generation. RAG. I'm just going to say RAG. Legal queries often do not admit a single clear-cut answer. Case law is created over time by judges writing opinions. So they write opinions, they overrule each other, they make them dependent on context and so on. Legal opinions are not atomic facts, and deciding what to retrieve can be challenging in a legal setting. Additionally, document relevance in the legal context is not based on text alone. Retrieval of documents that only seem textually relevant and are ultimately irrelevant or distracting negatively affects the performance on general question answering tasks. And that is known not just in the legal field, but generally in the retrieval augmented generation field. If you retrieve documents, if you retrieve grounding information, and that's wrong, it could even deteriorate the final output because now you're telling, essentially you have to view it from the training data of the LLM. So the LLM is kind of trained in the setting where it gets a whole lot of data collected from a whole bunch of places, but most of the time when it sees the situation in training that someone, posts a bunch of reference information and then draws some conclusion from that, most of the time that reference information is actually the relevant reference information to what the person's saying. So the LLM in its training data is very trimmed on these situations wherever there's reference data available to base an answer on these situations having the correct reference data. And therefore, it's probably overly assumes that whenever you do that in the prompt, that it's in one of those situations where it can quite rely on the reference data and should adhere to it quite a bit. So when you now retrieve the wrong thing, or when you don't tell the LLM something's been overruled and so on, you are causing a problem because it trusts you. Now, the problem with these systems is all of that is hidden from the human, right? If you include the human in the loop, you can get a lot better result. Like you include the human while deciding what to search for. You include the human in selecting the relevant references, ordering them, and so on, deciding whether they make sense in your context or not. And then you include the human while reasoning over the final references and arriving at a final conclusion. That would make for a fantastic system, but that would mean it's not super magic LLM. You just have one text box and it does everything for you, right? No. It would not be that. It would actually be a productive system, except it's not AI, it's not magic. It's just, you just pair you pair good UI with a good search engine with, good human in the loop interaction with an LLM. But that's not AI. It's not a chatbot. So that doesn't sell as well. So that's kind of the biggest problem I have. with this kind of thing. People are just too, their eyes are too sparkly from the whole LLM promises, so that they forget what they're good at, what they're not good at, and that um, you know, the principles of good software haven't changed. All right, in different jurisdictions, in even different time periods, the applicable rule, relevant jurisprudence may differ. Even similar sounding text in the correct time and place may not apply. They have an example right here. What are some notable opinions written by this judge? Now, apparently this judge here even has never existed, so this is kind of a false premise question. And still, via retrieval, that there's some references come up where the embedding similarity is quite close or something, and then the LLM responds saying, oh, there are these things, and then they take it apart. You can see how that goes. So the retrieved citation is a real case in hallucination-free in the narrow sense. However, it was not written by this judge. The second sentence contradicts the premise, and the decision is not notable as it was an unpublished opinion, right? So, and this is a very simple case. The whether something is relevant and whether the legal reasoning is correct and so on, these get much more complicated. So to think that an LLM would ever be, or at least at this point in time, would be able to do this for you is, let's say, unlikely. It's a bit of an outsized expectations right there. Yeah, so this sentence astonished me. These challenges, and the challenges of the problems of retrieval augmented generation, are familiar to lawyers using natural language searches as opposed to more deterministic Boolean searches on legal research platforms. And I have a particular problem with this sentence because it kind of shows how different things are just all lumped together currently. Nobody can get their terminology straight. So a natural language search just means that you search with natural language. Google nowadays, and I don't mean like the very recent Google AI answers and so on, just plain Google search is a natural language search. You just more or less type in what you're looking for, and it will give you relevant stuff, and you don't exactly have to hit the keywords or anything like this, right? It just understands you, is good at giving you what you want. That's a natural language search. Natural language search doesn't mean retrieval augmented generation. It doesn't mean that the output has to be produced by an LLM or something like it. It just means that you don't have to do these kind of Boolean searches anymore. So a natural language search can absolutely be deterministic. In fact, Google, apart from some personalization and ad features, is quite deterministic, even though it's a natural language search. I think what they mean is sort of an LLM output search, right? Rather than a search that just gives you back search results. Right? So not even the academics, who are supposed to be very systematic about this stuff, can get their terminology straight right here. Nowadays, as soon as you talk about AI and search, everyone is just like, it's like ChatGPT with browsing, right? Like, no, you can make good search engines, and you obviously see where I'm coming from. You can make great search engines that give you relevant search results that just understand what you want. So that it's not all or nothing. There are very good ways of making in-between stuff. And the in-between stuff is where you get productive, right? Like, the biggest drawback of these systems is they're trying to do everything end by end. Whereas if you were to mix technology and humans, like, technology is very good at like reading a lot of stuff very quickly, right? A search engine reads a lot of stuff enormously quickly and gives you back relevant stuff. An LLM can also, not as much stuff, LLM can also read a lot of stuff very quickly, point you to the relevant things, but then include the human. The human, who's very good at reasoning, who's very good at deciding which ones are actually relevant given their context and their legal knowledge and so on. Like that's a good system, not the end-to-end solve my problem for me system. That's just not feasible right now. And it's kind of stupid of the companies and the legal field who expects that to currently focus so much on that. And of course, they're going to run around like chickens, be like, oh, hallucinations, hallucinations. The problem isn't hallucinations. The problem is you're trying to use a tool for something that is not for. It's not for that. All right. Good. Hallucinations. What are they in this paper? They divide hallucinations in two categories. So they have a category of correctness, refers to the factual accuracy of a tool's response, and groundedness, the relationship between the model's response and its cited sources. Correctness, a response is correct if both factually correct and relevant to the query, and is incorrect if it contains factually inaccurate information. Note, it can also be incomplete or so. For example, if it just refuses to answer, right? So they categorize that as a refusal. And groundedness, do we have groundedness? Here. A response is grounded if the key factual propositions in its response make valid references to relevant legal documents, and ungrounded if the key factual propositions are not cited, and misgrounded if the key factual propositions are cited but misinterpret the source or reference in inapplicable source. So if the grounding is wrong, not just missing, but wrong, they call that a hallucination, misgrounded. And if the response, the output independent of grounding, is incorrect, like makes false statements, that's also a hallucination. Just refusing to answer is not a hallucination, and neither is the ungrounded. So if it just doesn't cite anything, then they also don't say, hey, this is a hallucination. Now, yeah, so you can see there is a big difference between correct and grounded. Helpful, right? That's a different thing entirely. What's helpful to the people who use it. Whether it's sourced in something real, right? Like all of these things are very different. So when you look at these results, remember what they call a hallucination is just it's either this or it's this. Now, the interesting bit, and that's what I was missing, is they don't divide the results between these two, right? They don't tell me how many of them were incorrect versus how many were misgrounded. It could even be both, right? It could be both. And those would give very good insights into how to make these things better. But they don't do that. They have yet different metrics, which they call accurate, maybe? Yeah, accurate responses, which are those that are both correct and grounded. Okay, so, and incomplete responses, which are those that are either refusals or ungrounded. So, accurate is when it's these with an and incomplete, it's when it's either this or this. So for example, it could be ungrounded and correct, or it could be grounded but refusing to give an answer. So those would be incomplete responses. Or it could be ungrounded and refuse, right? Which is probably most refusals are going to be ungrounded. In any case, yeah, they don't distinguish between these two main pieces of hallucinations. And given that the paper is about hallucinations, I would expect that to be a major part of it. But unless I've overlooked something, they never make that distinction. And that distinction would actually be the helpful distinction, because that would give you an indication of how to improve this. So I don't know. I feel that that's kind of a mishap on the part of the paper writers right here, but maybe I am misunderstanding something. All right, so the Yeah, ta-dum, ta-dum. Their data set, they construct a data set. It contains sort of a general legal research question. For here is an example, and here, yeah, you see how complicated these get. Has a habeas petitioner's claim been adjudicated on the merits for purposes of this, where the state court denied relief in an explained decision but did not expressly acknowledge a federal law basis for the claim? This is a real question that real lawyers care about, that they would have either in university or in their real daily practice. And you can, if you know anything about LLMs, you can see that even if you give them the best search engine on the planet about across these public documents, there's no way. There's no way. There's no way it can, this abstract, where the state court denied relief in an explained decision. It has to know what an explained decision is, where to find that, what, denied relief, what that means. Like, what do you even search for when you have something like this? Denied relief could either be an explicit term, or it could be a completely abstract concept that would require you to search for, and legal professionals will know, but these LLM, it's very, very hard for them to, grasp all of this complexity and do it all by themselves, right? And then even if they, let's say they get all of the relevant references and so on, then it's like, ooh, a legal professional would actually look, has this been overruled since, are there other opinions and so on? Are there other things to consider, right? Just from a legal practitioner's point of view, is there, I don't know, I for example, I know if there's some kind of this treaty with a country, it always overrules the kind of, I don't know, the more general rule. I'm not a lawyer, right? But yeah, it's giving tasks like this to an LLM is highly questionable. Yet jurisdiction or time specific, right? Where questions about circuit splits, overturned cases, or new developments, false premise questions. Those are a bit shady to make, because the tools are geared towards professionals and not towards sort of normal people who would be very often very mistaken about the premises, or would be like, if you use these tools, and you will know that you're supposed to ask your questions in a way that don't give a premise, but are like open inquiries, because these models, they're very agreeable. So if you give them a false premise, they will like to fulfill that premise even though it's wrong, and only very few times say actually that's wrong. Yeah. So I don't want to go too much into this. The questions are specifically tailored to RAG-based open-ended legal research tools. So they do aim to test the kind of systems that they're interacting with right here, and yada, yada, yada. So you can see the results right here, split up in a bit different way. So note how different this graphic is from the graphics before, just in sort of order. You can see the way you measure and the way you present the results and what the baseline is and so on makes a huge difference in terms of that. So Lexis, in terms of proportion of responses falling into accurate, incomplete, and hallucination, is ahead here with 65%. Practical law, very few accurate responses, however, also very few hallucinations. So the graph you saw at the beginning is kind of the flipped version of the red bars up here. But when you only look at the proportion of hallucinated responses while responsive, meaning not refusing, you can see that the proportion of practical law is high, because this bar here is almost as big as this bar right here. Again, depending on how exactly you display the results, how you measure, what you categorize, how you will get, you can get various effects right here. They also split it up down here in terms of, oh yeah, this I find also interesting. We also note that it is the system, and by it we mean Westlaw. So the system that's technically like bad, this is a system which tends to generate the longest answers, meaning Westlaw contains more falsifiable propositions and therefore has a greater chance of containing at least one hallucinations. Aha. So now they tried to make a system that gives more comprehensive answers and so on. The way these people measure hallucinations is, well, if in the answer something's wrong, it's a hallucination, right? So maybe the users actually like that. Maybe the users know that it sometimes doesn't say something that's correct, but maybe the users appreciate the more extensive answers and actually prefer that to a system that just gives them very short answers with a higher reliability. Who knows? But again, the way you measure, the way you assess has strong influence on ultimately the outcome right here. So keep this in mind, that this here is maybe one of the heavy contributors to the score, rather than the system just being worse by default. Hello, this is Yannick from the future editing this video. So this video is already super duper long, and you can see I'm skipping over quite a number of results here. Now the paper does a good job presenting lots of examples of the different stuff, and I do recommend that you look into this because it just gives you an idea of just how far away real world retrieval and reasoning use cases are from your simple, oh, here is our 50, clean documents that I want to ask questions about. So yeah, highly recommend that. I will not do this in the video, but the paper is linked in the description. Back to past Yannick. They split it up, yeah. What I found cool in this category, false premise, GPT-4 actually does pretty well. And that's a property, again, of retrieval augmented generation, where if you provide references, but your premise is wrong, then you're just loading wrong stuff into the context. So the more you do that, the more you convince the LLM that actually you're right and it should just adhere to what you're saying. After all, it's your assistant. It's supposed to please you, right? So GPT-4 without, and that's not the fact of GPT-4, that's just, this is a system where you don't do retrieval augmented generation, is going to perform quite well, of course. However, practical law, also very good, just kind of refusing the hell out of this, because it's just like, well, I can't answer that, or no, sorry, not refuse, yeah, incomplete answers, yes. I'll also be like, well, don't have anything about that. Yes, of course, you tested the wrong thing. All right, they have a bit of a taxonomy of errors, but as I said, they don't have anywhere they split up between incorrect and misgrounded, which I would really loved to see. However, I think it's obvious that a lot of the errors here happen because of poor retrieval. So many failures in the three systems stem from poor retrieval. The retrieval itself often requires legal reasoning. That's exactly why we make search engines that humans can use, and then, have the humans work with it, because the humans are aware, have the context, and have the education to assess what's relevant. And when you let humans and machines work together, it's better than when you just let the machine do everything end to end. And no, agents aren't going to solve that. Layering in more prompts and more prompts and more prompts at this particular point with the current LLMs is not going to solve that. I'm very, very sorry about that. Yes. Yeah, don't want to go too much into that. I do love their conclusion right here. The conclusion is this: AI tools for legal research have not eliminated hallucinations. Users of those tools must continue to verify that the key propositions are accurately supported by the citations. No shit. This comes as a complete surprise. Nobody in the machine learning community could have told you from the very beginning that this was going to be the conclusion of all of this. This is a shocker. I'm glad we went through all of this to arrive at this astonishing conclusion right here. Look, at the end of the day, this is software. Like, software is a tool, is technology that can help you, but you need to know what it does. You need to know what it's good at. You need to apply the correct tool to the correct problem, and then you need to be aware of how you need to treat the output. This has nothing to do with AI. This is just a property of software, and so many people just seem to forget that because it's sparkly and it's fancy and it's ChatGPT and it's woo and it's just a text box and it can do anything, and that's dumb. All right, this was what I thought about the paper. And yes, I'm sorry, academics. I'm sorry. No systematic. These are products. They don't owe it to you to give you access. No matter how much you stomp your feet, these are products. I don't like OpenAI not giving access to stuff because they, at the beginning, their whole premise was they're for everyone, and they rug pulled the entire community. That's the problem. But these things here, they're products for professionals, and they're under no obligation to give you access, and bullying them into giving you access by just reporting numbers on something that's not meant to be used for this task is not the way to go. And no matter how much you complain, it's completely fine. They're commercial products. They're allowed to keep stuff, for themselves and just sell it, and their customers need to evaluate how to use them. That's it. Thank you so much for listening, watching, and let me know in the comments. I know this was a bit of a longer paper and a bit more rant, but yeah, that's that. Thank you. Bye-bye.